Hello, welcome to Endemic Times. My name is Amira. I'm very excited to have back with us today Michael Lazar for our discussion on our post-Roe America. Michael, thank you so much for being back here with me today.
Oh, thanks for having me back, Amir. I'm glad to be able to have this conversation.
Yeah, me too. So why don't you go ahead and tell the audience a little bit about yourself, the work that you're currently doing, and also kind of your approach as we're going to be moving through this discussion on post-Roe America.
Yeah, so I'm a former police officer. I earned my master's in legal studies and with a focus in criminal law and procedure and administrative law. And then I'm currently a doctoral student focusing on law and policy and kind of the intersection of constitutional and administrative law and how it affects our lives. And as far as kind of how we move through this, I'll be looking at the legal aspect of everything, how it might kind of impact future cases, what the constitutional aspect of it all is, and then kind of how we might be able to move forward from these cases to either go back to codifying laws or some other common law problems that our legal system faces.
That's very good. I mean, that's very honorable work and studies to be undertaking, especially as we're entering this very tenuous time when it comes to our Supreme Court, its current very conservative makeup. And as we go through this discussion, really looking at those constitutional levels that they are looking at when they do their analysis of, do they just want to go back to just looking at the Constitution, or do they want to look at how we have evolved over time? So thank you so much. I'm really glad that you're doing that work, and I'm really excited for us to get into our discussion today. So as many of you know, both Roe and Casey cases have been overturned by the Supreme Court, and it has put abortion rights for women kind of at the forefront of our current political, social, and cultural discussions. So what we're going to be doing today right now is talking about some of the recent developments that have happened since Roe and Casey have been overturned. And we're going to be talking about three separate cases. There's a case in Florida of a girl that's been unable to obtain an abortion because the state considers her to not be mature enough to make this decision. And we're going to kind of go over that. Then we'll be talking about the case of the 10-year-old girl in Ohio that was a really big part of the media discussion a couple of weeks ago. And then also Facebook providing data over to the police regarding a girl that was looking to obtain an abortion out of state. And we'll be kind of looking at the intricacies of that. So, Michael, do you mind kind of running us through that first case, the Florida case, and kind of talking about its particulars and why this is looking to be kind of the start of the concern when it comes to how we go about our laws in this post-Roe world?
Yeah, so I think, as always, it's important to remember that when the media, especially the mainstream media, reports on things, they usually don't give the entire picture.
Mm-hmm.
And so you kind of have to do some independent research to find out more things. Some of the basic facts on this one, it's Florida v. Jane Doe 22B. That's how it was written in the court. It says that if a minor wants to obtain an abortion, that they have to get parental consent or guardian consent if they're in the care of the state. So this girl, 16, almost 17, doesn't have parents or is living without parents under the guardianship of the state. She's living with a relative, but not the guardian, and experienced some trauma. I believe a friend had died very recently before she decided that she did not want to get an abortion. And she essentially is saying, I'm not mature enough to do this. I don't have the financial means. The father doesn't have the means to support me or the baby. She doesn't have a job. She's still in school. A whole list of things that you would expect from a 16, 17-year-old minor to have issues with and be dealing with. And so she sought to essentially do a judicial bypass of requiring consent of her guardian. She stated that the guardian was on board with whatever her decision was, and that she had the full support. The judge noted times that she was credible, open, non-evasive. But part of the problem with getting the waiver for bypassing the waiver requirement was that she had to prove that she was mature enough in the court's eyes, and they looked at it is that she had mentioned before that she was okay with having the child and kind of changed her mind. The judge thought maybe the recent trauma of losing a friend was impacting the decision. And the judge did note that while she said the guardian had no issues, if the guardian didn't have any issues, she should have provided, or they should have provided, a notarized written waiver of consent for the minor to receive the abortion, which the minor did not have. And she also did not have a lawyer present, even though under the statute it's free of charge because of her situation. I will say that it is important that the judge found without prejudice, which essentially means that she can reappeal to do the judicial bypass, not requiring a waiver, or she can just get the waiver from her guardian, and she won't even have to go to court if she has that consent. But probably the issue with this, though, is that Florida is a 15-week abortion rule. Mm-hmm. I believe she's at 10 weeks right now. So it's only a very short window to try and either go back to court or get the written notarized consent from her guardian. They didn't really go over specifics of if that is difficult for her to get. But I can say, if you're 16 or 17, you may not know where to get to a notary. There's a whole bunch of issues about paying for a notary. I mean, there's a whole bunch of different problems that you could run into. And the other part is if she doesn't get it within the next, I'd say probably 4 weeks, a month, then she may not be able to get it at all and then be stuck with having a child, which the court has acknowledged she probably isn't ready, but doesn't quite meet that maturity threshold that they're looking for. And unfortunately, in the way the American common law system works, trial courts are given vast, deference when it comes to adjudicating issues, that it's really difficult to win on appeal or all the way up through the state court and even to the federal courts. So it could pose problems if they could use this as, this person is not mature enough, even though it seems fairly clear that she's not mature enough and presents a good case for not being mature, that lawyers or the state legislature could use this as kind of a jumping off point to either make further restrictions about abortion or kind of use this as, hey, the next time a 15-year-old comes up and wants an abortion, they're like, well, this minor hit all these boxes and still wasn't mature enough. You don't even come close. We're just going to toss this case out.
Yeah, this case really caught my attention, and it really just felt like this is one of those very ominous kind of stepping forward as we move through this kind of new world and new era that we're in, because it's one of the areas where law seems to be lacking the level of empathy that it needs to have, because that is, I think, one of my biggest complaints with the legal system is that there is such a lacking of empathy when it comes to this. Because to say that she's too immature to get an abortion, but mature enough to go through the entire process of a pregnancy, all of the risks, all of the cost, and then the possibility that, she'll have to put the child up for adoption, which seems very likely if she isn't able to get this repetitioned for this decision. So it's just as a woman, as a human, this just is very concerning to me on that particular level, because it feels like this is showing that the courts are going to have, especially depending on which state you are in and which laws are in place. Like you said, Florida has this 15-week timeline, very similar to Mississippi, which is the case that ultimately got Roe and Casey overturned, having that 15-week limitation. So it's just one of those things where I get very concerned with kind of the forward moving process of our legal system when it comes to women making this decision for themselves. I am really glad that she will have the opportunity to repetition this. But like you said, the time frame for this, the bureaucratic court system doesn't move expeditiously. So it'll be really interesting to see kind of where this case goes, because I do think personally it has a lot of possibility for some kind of possibly sad repercussions that come from this.
Yeah, definitely.
Yeah. All right, so moving on to the next case. So this is the case of the 10-year-old girl in Ohio that sought an out-of-state abortion. So this was something that was discussed in the mainstream media. There was quite a tizzy because it started out with being basically like fact checked at first. People weren't
Yeah.
believing this story. They were not believing the doctor that brought this information forward, because this was a doctor that was trying to explain the importance of having this accessible, especially when we have situations like this where this incident occurred because of rape. So Michael, do you mind kind of walking us through that Ohio case as well?
Yeah, so there's not a ton that's known about it,
Mm-hmm.
given the age of the victim.
Yeah.
A lot's going to be held in court until it goes to trial, and probably not a ton of it's released to the public. But we do know is that she traveled to Indiana to receive an abortion. That was covered widely in the news.
Mm-hmm.
Recently, the police arrested a 27-year-old male who admitted to police that he had raped the girl twice. There's no indication from what I saw whether he was a relative to her or not, but that could come out later. But I think one of the important parts here is that the Ohio abortion law bans it after 6 weeks, which, I mean, from my understanding, limited understanding, you may not even know that you're pregnant at 6 weeks.
Yes, that's correct.
So there's a lot of consternation around, how early they ban abortion. But then also, they don't have any provisions that allow for, exceptions to that for rape and incest. So essentially, a very short abortion window that women are entitled to. And then even if they make it within that window, if it is rape or incest, there is no exception. So they almost have a double fight to be able to figure out that they're pregnant before 6 weeks, then be able to go get an abortion. But then if they can't do that, let's say it's 7 weeks, there is no, I won't say loophole, but there's no workaround for them to get an abortion if they were raped. So essentially kind of making, two wrongs in a sense, because now not only does she have to live with the fact that she was a victim to a very violent crime and that trauma, now she will have to travel, which causes a financial burden. And obviously the 10-year-old wasn't paying for that. The parents or guardians were. But it still puts a financial burden on the family. It puts a financial burden on the individual if it's an adult who's traveling out of state. If, travel, gas, plane, hotel, the cost of the procedure itself. So it puts a lot of burdens on women to just receive basic health care, at a fundamental level. And I think another thing is people like to say, oh, well, there's not that many minors that have to get an abortion, which I think is a really odd argument to go with. It should be no minors that have to get that because of, and we shouldn't be talking about, well, rape and these sexual crimes. Like that shouldn't be a thing anyway. But the Guttmacher Institute in, I believe, 2013 did some research, and about 7,000 girls age 14 or younger were pregnant, which is a really alarming number. And I probably have to go and look into like how many was that from incest, rape, or anything else. But regardless, it's still a really high number, and over half were ended in abortion. So now if we just took that as a number every year, that's potentially 7,000 very young children who are going to be subject to now maybe not being able to get that. And so now what do they do? At 14, I believe, you're starting high school or eighth grade high school
Or
time.
like in high school, yeah.
Yeah. So I
It's
mean,
very young and very immature
I mean,
levels. Yeah.
you're not really mature. You're definitely not financially stable enough
Hmm.
to do that. You're not going to have a job most likely. Um, I don't even know what medical ramifications could come from having a pregnancy at that age. So there's a whole list of factors that I don't think are properly addressed
Hmm.
in the Ohio's abortion law, which at the end of the day, it's the legislator's job to have medical experts in to get these facts to know how to best create a law that will actually serve the public interest, not just a specific ideological interest.
Yeah, those are very good points. One of the things I was thinking about is that some of like the recent data that I've seen when it comes to women that have had an experience of sexual assault or rape, I believe it's like now like 8 in 10 women or something like that. It's a very astronomical number, and these are things that do not get discussed in this discussion of abortion, pregnancy, healthcare, things like that. And it also does seem like our culture isn't doing much to work on what are the systemic issues that are causing this prevalence of sexual attacks against women. I mean, it's of course not just women, but it's predominantly affecting women, especially in this discussion.
Yeah.
Um, and then the other thing that I was thinking about as you were going through that is the, again, it's that level of the lacking of empathy, but also in states like Ohio, very similar to the Mississippi case that we'll get into, these are states that have really bad mortality rates when it comes to pregnant women and women that see their pregnancy through. They don't have healthcare options. They don't provide any kind of state aid for women that do end up going through with their pregnancy. But the risks of these pregnancies, especially like you said, for girls that are at the age of 14, there are a lot of risks, both health wise and also mentally, because it puts such a psychological effect on these girls. The 7,000 girls 14 or younger in 2013 is quite an astronomical number. When you sent that information to me, I was very shocked.
Uh,
Um,
I'm very surprised when I came across that. And
yeah.
I don't want, I would hope it hasn't gone up. Um, I could only hope it would go down, but I mean, regardless, it's still too high of a number. It's a real problem.
Yes. I wish that more lawmakers would look at this kind of data and realize that it's not about an ideological stance. It's not even a religious stance. It comes to, we have an issue in this country that we need to be looking at when it comes to the way that women and girls are treated, the way that boys and men are being, I assume, kind of raised. Because I don't think that we have enough of an emphasis on consent, the ability to say no and stand up for yourself, and also have that individual listen to you, and kind of just dealing with all of these sex crimes that we see across our country, across the world. It's so horrendous, and it has such a deep effect on everyone involved, but especially for these young girls that
Yeah.
have to deal with this.
I was gonna say, kind of on a note with this, there was actually a case in Minnesota, I believe last year, where a woman was drugged and raped, and she actually lost in court because the legislator had defined specifically what constituted um, like essentially mentally unable to make a decision on your own. So because they had such narrowly defined that, voluntary intoxication did not meet that standard. It was only involuntary. So essentially, she wasn't really
Wow.
drugged per se. She had had a couple of drinks, was out partying. She had also taken some prescription medication of her own. So she had done all that before she went out to go party, clubbing, whichever it was, and then essentially got picked up outside of a club because the club turned her away. And this is all in the court documents. I'll definitely have to send it to you. But the club turned her away because the bouncer was like, "Yeah, no, you're too intoxicated. You can't come in." And then she got picked up by some people. It was unclear if she knew exactly who they were. But they go back to the house. Obviously, things happen. Wakes up, very noticeably knows and defines that she is not consenting to this action, and then loses in court because of how the Minnesota State Legislature defined that like mental ability to make decisions, and voluntary intoxication was not one of them. So even in a case where that happens, we have, legislators that aren't realizing that when they narrowly define things, the court is almost bound to interpret based off that statute. And that was the court's reasoning, even though I think the common sense, and even the court notes, the common sense would lead one to believe that this was obviously a rape.
I mean, if you're inebriated and especially if you're saying no, that puts the onus on the other individual, not on you personally. Yeah. But it's unfortunately something we continue to see. It's happened. I mean, since even I was growing up, there would be snide comments made by people of like, oh, well, she was wearing a short skirt, so she asked for it, kind of thing. And it's one of those things where it's like, judges, legislators, these are all people that are human beings. They all have their own beliefs, and they also have things that they can say and do wrong. And some of them might even kind of hold those beliefs, but don't necessarily judge a case on that in particular. But everyone does have their biases. And it's one of those things where, especially when it comes to alcohol induced, drug mental states and things like that, we don't have any good laws, I think, especially when it comes to sexual predation, sexual assault, and rape. Like it's why people have been kind of screaming at Democrats of like, you need to codify the right to an abortion into law. I would say we do need to go a step further, and we really need to start looking at the broader aspects of how do these incidents occur, what can lead to a woman, a man, or non-binary individual, like what would lead them to being affected in these different ways, and have more laws that kind of help to broaden that aspect.
It was crazy. Essentially, if you voluntarily decided to go out and have fun with your friends, that by the statute that you technically were not covered, even though that you were a victim of a violent sexual crime. So yeah, there's work to be done.
Yeah. All right. So moving on from that sad and depressing stuff. So the last case we're going to go into before talking about the Dobbs case is Facebook handing over messages on abortion. So this has been another really big thing in media that has been talking about this, especially also period tracking apps, health apps, things like that, especially for women in particular, the concern about having this data on your phone because of these social media companies that could possibly share this information. So recently, a 17-year-old Nebraska teen and her mother were found to be mishandling fetal remains, concealing a death, and disposing of the human remains because she had an abortion. Facebook handed over those messages pursuant to a warrant obtained by the authorities, and messages showed that the mother had apparently coached the daughter on how to take abortion pills, which does contradict the story a little bit when it was told to investigators that the daughter had miscarried. So Michael, do you mind kind of going over some of the contradictions to this story initially from what we saw at first and kind of what we're now seeing in this report?
Yeah, so I think initially the kind of firestorm in the media was Facebook is handing over messages, trying to criminalize someone getting an abortion. Which obviously, if that was the case, that would be a pretty big step for them to do. Once you dig a little deeper, as you mentioned, what ended up happening was the investigators. It's kind of unclear on how they came about knowing this. what essentially ended up happening is the teen was between 23 and 28 weeks pregnant. And Nebraska actually has a 20-week window for abortion. So relatively similar to how Roe and Casey were. But the problem is that at 23 to 28 weeks, she was already outside of the abortion window. And when it first got reported, it was she miscarried. Which obviously is a very tragic and traumatic thing, but there are legal and medical steps that one does have to take. You can't just go and bury the body in the backyard kind of thing, even if you have a miscarriage. So I think that was part of it. And then as the investigation kind of starts unfolding, there's another suspect, a 22-year-old male, who comes into the picture, and he eventually starts talking to investigators. And what ends up coming out is that the teen had taken Pregnant. Hopefully I'm saying that correctly. It's an abortion kit, but according to the manufacturer, is not designed for late-term abortions.
Okay.
Because they said it could cause health issues. So it's designed for abortion, but just not as late-term as the teen was. And then even if we kind of skip past all that, once the abortion takes place, instead of just notifying authorities or going to the doctor, they try to burn the aborted fetus and then bury it. So I'm not sure why exactly. It doesn't really get into why they believe that they needed to do that. But that's kind of where it came from. And then they filed an affidavit with the court outlining all the reasons why they want the messages from Facebook, their evidence for getting those messages. And all it really did on the Facebook messages was confirm that the mom was trying to get this abortion drug, that the teen was a lot further along in pregnancy than was originally believed, that it was not a miscarriage, it was an abortion. And that's where it came out that one of the moms said we have to hide the evidence, and then led to the attempted burning and then burying of the fetal remains. So that's really what that whole kind of issue is. I don't know if it's really an abortion issue so much as it was how the mom, because I'm not going to put anything on this teenager here, because she, is just kind of going with what her mom is telling her.
Of course, yeah.
So this is kind of one of those weird scenarios where, if they'd wanted to have an abortion, Nebraska has a 20-week window, which is fairly, I believe it was about 24 weeks under Roe and Casey was about the standard. So it was pretty close and still is. And they could have gone to a doctor, seen that. So it's kind of a weird case because it's not really Facebook purposely trying to get someone criminally charged for an abortion. It's this person was lying to investigators and then tried to bury a fetus after attempting to burn it, which I think is really what more of the focus should be, more so than the abortion aspect of it, because there's nothing that really criminalizes the abortion. She's not being charged with obtaining an abortion late term. They're being charged with essentially trying to burn and mishandle fetal remains. But it is kind of a weird, it's a weird case. I'll say it wasn't what I thought it was going to be. When I started looking into it, I really thought, I was like, okay, we have another case like in Florida. This teen was trying to get an abortion, and then they were probably talking about it on Facebook, and now the police are subpoenaing, trying to get these records. And then once you start getting into it, you realize this is really about the mom gets the abortion medicine for the daughter, which I don't think most people would have any issue with. But then I would say it's really the handling of what occurred afterwards is what they're getting in trouble for. It's not for the abortion, it's for how they handled after the fact.
Yeah, no, I agree. I was definitely one of those people, like as I was going through, the news that day, this was one of those cases that came up, and the only headline on so many of the articles was, Facebook hands over messages about
Yeah.
abortion, and it very much sensationalized. And at first I was very like, what the hell, Facebook? Like another reason to dislike you. Um but thank you for going in and kind of doing a deep dive on that research, because not everyone goes past that headline. They just see that and then they immediately are like, oh, F Facebook, they did this thing. But this is a very different case. One thing I did kind of was thinking as we were going through this is like, this kind of looks as like one of those cases that would be right for conservatives to use to say, this is why we shouldn't allow any kind of abortion. But then there would also be the retort that, well, services are available. This was still within the viability like timeline to terminate the pregnancy based on the current laws in the state. This was more, I think, just one of those kind of one-off cases where maybe this is more of like a mental health kind of case, because the disposing of the remains, the burning, like that aspect just seems very extreme, very
Hmm.
intense. Maybe they were trying to, I mean, it seems like they were trying to conceal this from how it was, from what happened. Um, but it's one of those things where we do need to do our due diligence as readers, as people that absorb the news and listen to it, that before we just kind of spout off our anger about something, we do kind of need to do this deep dive and look at what are the particulars about this case. Because while it's concerning that Facebook is handing over these things to the police, it makes sense in this situation because this is very, very extreme, very concerning. My only concern, I think, moving forward is that this would be a case for conservatives to use to really kind of push back even more on abortion as a whole.
Yeah, I think that's, I mean, a concern that, they might try and use in any kind of borderline um, case or issue surrounding abortion. And that dates back to, the 1980s and Ronald Reagan,
Hmm.
um, about kind of the conservative push for, you know, pro-life, no abortion. Um,
Hmm.
and I think it's important for people to remember too, while the media has to kind of give that flashy headline to kind of catch you, or either maybe you just read that first line, maybe you read like the first two lines,
Hmm.
and don't read any further. I mean, that's kind of their goal. It's not until like you go further into the articles you're like, oh, okay, this is very different. And it is also
Hmm.
important that Facebook didn't just hand it over on their own, like, hey, here you go, police.
Yeah.
We don't need anything. I mean, it was a court order,
Hmm.
which meant they had to go through and present enough evidence to a judge for them to even sign off on getting the warrant to get those records. And it was specifically between those people. So it wasn't a broad, you can go grab anything. It was about
Hmm.
the specific incident and anything that related to that incident. Um, so I think it's important for people to know that, so that way they don't think Facebook's just handing out any kind of message data, just free,
Yeah.
free of charge.
Yeah. I mean, we've seen that they've also had to do that, previously with court issued warrants where, it can be for a killing, something that's, like activity that's happened on someone's account. So it does make sense. There are the legal parameters there for allowing Facebook to do this when it's pursuant to a warrant. I do think that people's concerns of just like how easily and quickly are they going to provide information? Will it always just be court ordered, or will it be, oh, we were persuaded, or things like that?
Yeah.
It's one of those things I don't think we're going to know until we actually get there. But in this case, because like I said, I was one of those people that was very like quick to anger and frustration with this because I saw the headline. But doing that little bit more of digging, it's like, this isn't what I thought it was. This was in
Yeah.
accordance with our laws, with the courts. So there was all validity for Facebook to hand over this information. All right, so moving forward, one of the things that we really wanted to do here today is to do a deep dive into the Dobbs case. So Dobbs is the case that has allowed the Supreme Court to find that they wanted to overturn Roe and Casey cases when it came to abortion rights. So as we're diving deep into the Dobbs case, the reason why we're doing this is because there is a lot that has not been disseminated to the public, mostly just because this is an over 200-page court document. There's so much here. So we really wanted to take the time to go over this and bring this to you. So we're going to kind of do a bit of a legal analysis of this. Both Michael and myself have legal backgrounds, so we're going to try to move through this pretty quickly, but also give you the information from the inside of this, the concurring opinions and the dissenting opinions, because there are quite a few nuggets that are making both me and Michael a little concerned for our future. One of the things that happened in Dobbs was the issue before the court. So that was that the state of Mississippi was asking the court to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy. So this is several weeks before the point at which a fetus is now considered viable outside of the womb. So in both Roe and Casey, this aspect about viability of a fetus was a big talking point. It was something that was examined by the court, and one of the reasons why this Supreme Court justices felt in this case that they were going to be able to overturn both Roe and Casey. The broad question that was being examined by the court when it came to Dobbs and overturning Roe v. Wade and Casey v. Planned Parenthood is whether the Constitution itself, confers a right to obtain an abortion. And so there were a few factors that were looked at when it came to whether this right is in the Constitution. And these were also explored in Roe and Casey. And that was looking at the 14th Amendment's liberty protections of a particular right, whether the right to obtain an abortion is in our nation's history and tradition, and whether the right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. And then the second aspect that the court was looking at is a very legal term called stare decisis. And so this is a role in protection interests of those who have taken an action in reliance on a past decision. So basically this is a case that has been decided and other people have relied on this court's case decision in moving forward. And by having that case decision, more laws and more movements can be made based off of that particular decision. Looking at the findings by the court, they found that the 14th Amendment does not protect the right to an abortion. And that was their big decision when it came to overruling these two cases. And they said that at the time of the adoption of the 14th Amendment, over 3/4 of the states had adopted statutes criminalizing abortion, and that from the earliest 20th century until the day Roe was handed down, every single state had such a law on its books. So we're going to get a little bit more into that in just a second. But I wanted to also bring up some of the precedents that they used in the second aspect of why they were wanting to overturn these cases. And that's looking at the Brown versus Board of Education, Plessy v. Ferguson, and West Coast Hotel Company v. Parrish. So these are kind of the three seminal cases that they used in overruling precedents. So basically, these were cases that overruled previous court decisions. And they used those three cases to say that that is why they can overrule Roe and Casey, get rid of them, and move forward with the Mississippi case in Dobbs. So Michael, do you want to just kind of give us a little bit of a rundown of like kind of your initial thoughts on this, and then kind of some of the other factors that came through when it came to overruling Roe and Casey?
Yeah, so, I mean, there's a lot to unpack. Like you said, it's a very lengthy opinion from a court. Mm-hmm. And I think my probably initial reaction and everything was not surprised given how the court has turned, but also because from a constitutional standpoint and from a legal aspect, the court's not wrong. Like they had plenty to kind of say, hey, it was never right in the first place and we never should have done it.
Mm-hmm.
Obviously, the problem with that is it's been something that's been essentially on the books, even though it's not officially on the books, which is kind of another problem that I'll bring up about the common law system, is that now you give it back to states and supposedly everyone has more control in your state because you have a little bit more direct action on who represents you. But it's essentially the same people who've been there for a long time, and they already had, as we saw, laws ready to just trigger just like that and vastly restrict abortion rights. And I also think there's some issues with the 3 cases you mentioned that they used to kind of justify why they could overturn this on top of the constitutional aspect of it. And then, yeah, so I mean, I think it's important, like Roe essentially used privacy, which is it's not mentioned in the Constitution. So that was kind of a tricky sticking point, that when the court first ruled in Roe that privacy was covered as a fundamental right, it wasn't really, but they said that essentially the common law tradition and history from the late 1800s to the mid 1900s had established an individual's right to privacy. So you kind of already see there they established a history and tradition, and that was in specific areas of life, whether it be medical, psychological, or family. And in Roe, they ruled that women had an absolute right to abortion for the first trimester, and we kind of went through the trimester framework. And then once Casey came about, Casey really didn't change too much from Roe, but what it did was it changed it to the viability standard that we had. They expanded on Roe, and instead of using privacy, they used 14th Amendment's due process clause looking at liberty, because they define liberty, the right for an individual to be protected from state procedures. And at the core, it was essentially how someone kind of defines their life. And again, they held under common law through history and tradition that constitutional protections regarding liberty are well established in law and substantive law and procedure. So they acknowledged essentially that society would disagree over morality is going to forever be present. But the courts can't allow that disagreement to drive law, which is interesting that in Casey, they hint at morality should not be what drives the law. It should be what is in the best interest of the public and the individual. And then they also referred to the 8th Amendment about the burden, cruel and unusual punishment. They refer to how the burden that is incumbent upon a woman who considers or has had an abortion, or to see pregnancy through, is a significant strain on the body and mind. So they make a lot of points about how there are several constitutional amendments that can be applied to abortion. And then I did check with several pastors because I wanted to be sure. The Bible does not specifically ever mention abortion. The only time it's really mentioned is not actually by name. It just implies that when a fetus is lost through someone else's action, that the compensation is that of property. So that's an important aspect to note, that it's not actually mentioned in the Bible and it's viewed as property until it's born.
Interesting.
Yeah. And then once, we get into Dobbs, like I said before, they're not technically wrong for overturning it, because they viewed it as that the amendments in the Constitution only protect substantive rights, which are those that are enumerated in the Constitution. right? So that's 1 through 9. And then fundamental rights are just those that are implied rights, which is kind of what, in essence, the Ninth Amendment refers to when it's talking about, it's anything that's not enumerated should not be thought of as an exhaustive list of all rights. Other things that are not are retained by the people. And then, kind of, as you mentioned, there's this long history and tradition of, abortion laws and criminality, whether that was before fetal movement, post-fetal movement, wide-ranging aspects of it. But it was all at the state level, which is kind of the important part, is that people actually had more control. Although I would mention that when the 14th Amendment was adopted, it was in the mid-1800s, and it wasn't until the 1920s that women had the legal right to vote on issues. So I think that's kind of an important aspect that they don't really mention. And as you went over, kind of the problem with saying, using Plessy and Brown as examples is why they would overturn, and go away from stare decisis, which they said was essentially a recommendation. They were not bound by something that the Supreme Court has used for centuries, was that Plessy and Brown were giving rights to people and actually went against history and tradition in the American legal system, because up until that point, the American legal system was very skewed as to taking rights away from minorities. And it wasn't until those two cases in particular that they actually got rights. And the court said, no, they've always should have had these rights. So it's kind of a weird comparison to make, that we're essentially taking a right away that was never really a right because we ruled wrongly. But we're going to refer to cases where we gave rights. So it's kind of like we're kind of picking and choosing what history and tradition of law that we're actually going to follow. So it's an interesting way of wording some of their arguments.
Yeah, it was really interesting. In the dissenting opinion, they kind of talked about it. There's a lot of hypocrisy going on with the majority opinion overruling this case because of those precedents that they were using, like you said. Because they were giving rights, not taking them away. And the other thing, too, is that both Roe and Casey had been understood for a good 30 years plus. And even some of these Supreme Court justices, as they were being put up as nominees to the court, they said that this was something that they were going to retain, that they were not going to do anything with it. But there was, of course, the understandable fear from many that just because they say this doesn't mean that that's actually what they're going to, that they're going to hold to that. And that has been the overwhelming concern, even since the Roe case was handed down, because we knew that there were a lot of loopholes and legal areas of gray that could lead to something like this happening, which was why so many people over the last several decades have talked about the need to codify this into law. And especially now with this case coming down, it puts a lot of other rights into question. So that comes from, contraception, same-sex marriage, interracial marriage, things like that. So it's one of those things as we move into some of the concurring opinion aspects from Justice Thomas that are very concerning because of just the language that he's using. It's very to me, it's a little bit forceful, but it also feels like it's kind of a roadmap for the ultra conservative case of moving away from looking at a broader aspect when it comes to our laws and just focusing only on what are the rights that are in the Constitution, because that, as we know, like you were saying, in the 1860s, women didn't have the right to vote. That was in 1920. So a lot of the case law that they were looking at in the majority opinion, some of it took place in the 13th century, the 17th century. They were, looking at some things that happened in Europe. I believe believe it was like in France. They did a lot of language analysis of quickening, pre-quickening, when you would feel the baby move, things like that. And it's just in all of those aspects, as the dissenting opinion kind of talks about, women were not looked at as a full-fledging, human being that had the full rights and protections under the Constitution. So it's like, so my concern, as we're in 2022, is this going to be a recurring thing where it's, oh, we're just going to go back to the Constitution? What does the Constitution say? Because women had no choice in the Constitution and how it was written. And even our amendments that we do have do leave a lot of, I think, kind of leeway and gray areas for us. And I kind of wish we could just redo our Constitution because things have so drastically changed. What's your thought on that about changing the Constitution?
I mean, I think that'd almost be impossible now. Yeah. I mean, we can barely get, politicians to agree on anything other than things that serve their special interest rather than the
their favorite
interest.
Corporations.
Yeah. So, I mean, changing the Constitution or redoing it all, I mean, I don't even know if it's possible or, what it would look like. I don't even know if you could get enough states on board with, changing it to be able to ratify, to get an amendment. I mean, there's so many problems. But I think one issue, especially when it comes to law, and especially constitutional law, is that it's very open, as you said, to interpretation. And I would argue that it's not so much the Constitution that is wrong per se, but it's how legal scholars interpret it and apply it to the world. So they kind of interpret it and go, oh, well, I'm going to look at it from exactly how it says in the 1700s, as opposed to understanding that even the founders kind of talked about this, was that there were some founders that didn't even want the Bill of Rights in the Constitution, not because they didn't think people deserved them, but because they didn't think that you should have to enumerate rights that were just blatantly obvious. You said in different terms, but that's essentially what they said, was we shouldn't have to enumerate rights because everyone knows that you should have them. So why put these in here? Because they were fearful that it would lead to essentially kind of what we're facing now, that, well, because it's not there, you don't have that right. Where they're like, well, there's a lot of kind of nuances, which is why it makes constitutional law very difficult to tackle. I mean, we can also look at, there's a whole bunch of other cases that the Supreme Court has done throughout history, and just other things that have happened. I mean, they didn't even have, technically, the Supreme Court also doesn't technically have the constitutional authority to do judicial review. It's nowhere in the Constitution that they have that. They actually gave themselves that authority and power through one of their own cases, which is kind of ironic. But, then you have, up until the early 1900s, women were primarily the ones in the OBGYN practice. It was nurses and midwives, and then that shifted to being male-dominated professions at the time, as doctors. And then they kind of started taking that over. So then there was that shift, and that's when you start seeing all the abortion bans and the restrictions on abortion and all the slew of things. I mean, there's a lot of different cases. I mean, in the 1920s, there was sterilization acts, there was eugenics acts, a lot of them targeting women of all, ethnicities and races. It wasn't just specifically targeted. I mean, there was some that were very targeted, but there was many that, were targeting them that were essentially using a Supreme Court case that had to do with mandatory smallpox vaccines to justify tying tubes. So there's a lot, the Supreme Court's decisions have such a wide sweeping impact that I don't know if they even fully understand the impact that was created and all the ripples that will now, I mean, for probably decades, come from this decision. And then I know as we're going to get to the concurring opinions, at least one of them from Thomas is concerning, to say the least.
Yeah, so let's get into that because so Justice Thomas, he's a particular figure, and I don't agree with many of his positions. One of the really concerning aspects in this case, so in his concurring opinion to the majority's decision to overturn Roe and Casey, he said this particular thing: substantive due process is an oxymoron that lacks any basis in the Constitution, because the Due Process Clause does not secure any substantive rights. It does not secure a right to abortion. And then he goes on, he says, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Because any substantive due process decision is demonstrably erroneous, we have a duty to correct the error established in those precedents. And so that right there, like, I have not seen anyone really talking about his concurring opinion in this, just because it is such an eye-opener to what he's thinking, what I think that a lot of conservatives are thinking. And I felt as I was reading this that he is giving them a roadmap of how to go about doing this. Can you talk a little bit about the effect that this is, like, if something like this was to happen, what would that effect look like?
I mean, that effect, all those cases have to do with, gay rights, marriage rights, healthcare for a lot of certain things. They could essentially apply to almost anything that the court has ever reviewed, that they feel that is, substantive in nature. I feel like it's a weird thing to cover, because, the court has a history of covering that the Due Process Clause, and which is found in several areas of the Constitution, it's not just one specific spot, does cover those rights. And I think the fact that he's saying that it's because it's not enumerated in the Constitution is essentially what he's saying is because it's not enumerated in Amendment 1 through 8, even though 1 through 10 is the Bill of Rights, technically they look at 1 through 8 as the substantive rights. Because it's not listed in there, it doesn't exist, which, has so many implications. It's almost impossible to, it's almost impossible to know what it could mean, because you could argue that a lot of the things when it comes to privacy, that the Fourth Amendment has been used to cover for your privacy when it comes to data, online presence, even some stuff with your home. Well, technically, there's a lot of things in there that could be viewed as, well, it's not actually enumerated. It just says life, like property, things of that nature. So then you would have to get into legal battles of, all right, well, what constitutes property? And if they went back to an older, pure, I don't even know if it's really pure constitutional view of property. You could be looking at so many different issues just on the property aspect alone. All the things about free speech. Free speech is covered under the First Amendment, but there's been a lot of case law that kind of curtails certain things and allows other things, but that could go away. The Second Amendment is always a hot topic. I think it's never going to be, a cold topic in the country, but that could be another thing that people that are, wanting more restrictions on guns in the Second Amendment, that could get taken away, and you could just essentially get whatever gun you want to, or who knows what. So his opinion and kind of how he's laying it down is is concerning because he essentially just kind of says, hey, we're just going to toss out everything that we've done and we're just going to go back to just the Constitution and that's it. We're not going to look at anything else, which may have been fine when the country first started and had its first few cases and you didn't really have much to go off of, but not when you've had, a couple, 200 years of legal history and tradition. I don't know what legal history and tradition that would be following, and that's in their own majority opinion is what they say or they base things off of. So
there's two other things I wanted to mention of the Thomas opinion. So it's him talking about jettisoning substantive due process because it's particularly dangerous. And he says that it exalts judges at the expense of the people for whom they derive their authority, that substantive due process distorts other areas of constitutional law, and that it's often wielded to disastrous ends. And then he goes on to say, in future cases, we should follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds beyond that a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with that textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. It's just so to me, because it's like you can be one of those justices that is, primarily only looking at the Constitution. But for someone like Justice Thomas, who has quite a history when it comes to his opinions and his decisions on cases, to now be bringing this, that he's wanting to basically go back to at any, like, as the first opportunity that they get to get rid of substantive due process. It just feels like it's kind of getting rid of any progress that we've made when it's come to understanding rights and privileges and liberties and protections for people within that. Because, when you look at life, liberty, or property, when it comes to the Constitution itself, that was only looking at life, liberty, and property pertaining to a particular aspect of the population. So it's one of those things where I'm like, does he understand? I'm sure he does, but it's like the question I have in my head is like, do you understand what you're doing? Like you're taking away so much progress if this is something that you want to move forward with.
Yeah, it's difficult to understand where he's kind of coming from. Because I'm not sure what does he want to go back to, because it's essentially saying that these don't serve any legitimate purpose and we don't really care about the fairness or, equality of the law, which, I feel like the founders' whole idea was that the Constitution and law system was supposed to protect individual rights and serve the public interest. So I'm not really sure how getting rid of this due process aspect that the courts have used for a very long time would really serve any individual's best interest, maybe a select few's best interest, but I don't see how it could also either, serve a public interest, because if you just take one of those cases, and I'm pretty sure it's Oberfell that has to do with gay rights and marriage in particular. If you get rid of that, well, you're just now essentially taking away a right from a whole part of the population and essentially telling that they're wrong, like you never had this right, which again is the exact opposite of what Plessy and Brown did. So It's very bizarre that he would be so heavy-handed with, this opinion and wanting to eliminate it from jurisprudence altogether, which I don't think would actually happen. That'd be a very difficult thing, I think, to really implement, because that would change too many things. But it's just bizarre because the court itself, even in most of their majority opinions talks about the due process clause and its how it protects certain rights, but then also takes into account history and tradition and everything. So, I mean, essentially, like I said before, if his opinion is the future, they're going to take everything that the legal system has done and kind of just toss it out the window and say, well, we're just going to start fresh, which,
Yeah.
I mean, you could look at it as maybe a positive if, the legal system functioned the way it should, but it doesn't.
Word. That is very true. I mean, I definitely think that it's one of those kind of like long game opinions, because I think that the only way that you could really overturn Griswold, Lawrence, and Obergefell is by looking at the substantive due process. Because it was, it's even things that they did try to use in both Roe and Casey to say that, this is why this right to an abortion is so important. Yes, it might not be, delineated exactly in the Constitution, but it comes from this aspect, this broader aspect of, what are our own personal rights that we can have. So the next thing I wanted to move into while we still have some time is the Roberts concurring opinion. So I think both me and Michael, as we were looking at this, kind of agreed that he had a little bit more of like a steadied stance when it came to his concurring opinion, because he agreed, but kind of up to a point with the majority decision. He didn't believe that they needed to do a full overturning of Roe and Casey. He felt that that they could have recognized the right, but also reaffirmed the doctrine of stare decisis, so keeping those cases intact. Because we know that there are other cases like Griswold, Lawrence, and Obergefell that talk about Roe and Casey in their within those factors in deciding those cases, because it was both of those, Roe and Casey, were seminal cases for the court. One of the things that, Roberts talked about is, looking at the two distinct rules of constitutional law. So that a woman has the right to choose to terminate her pregnancy, but that such a right may be overridden by states' legitimate interests when the fetus is viable outside of the womb. I felt that was, like, as someone who is pro-choice, this part of his opinion I agreed with pretty much, because I'm like, I understand that there are going to need to be some aspects in law in states that look at, the timeline of the pregnancy, and that at a certain point, getting an abortion is considered too extreme. Those are things I don't disagree with. I just wish that there was more like medical professionals that were kind of part of the discussion that can, look at just science and biology and facts to kind of help understand what the actual timelines are. Because like we looked at, with the Ohio case, they only have a 6-week. Florida, Mississippi, and a lot of other states, they have 15 weeks. But in like the Facebook case, I can't remember which state that was in, but they had a 20-week. So it's like there lots of states seem to have an understanding of the viability of the fetus and the timeline of the pregnancy and when it's okay and when it's, not okay to get an abortion. Was there any particular areas of the Roberts opinion that you found kind of intriguing as you were looking at it?
Yeah, I mean, I think the big takeaway I got from his opinion was that he recognized that, I think the biggest one was that he would essentially get rid of the timing rule, but didn't see any need to kind of address the basic right itself, like the right to get an abortion. So, I mean, he's smart enough to know that there's never going to be a consensus of when life begins. If you look at religion, a lot of them will say conception. If you look at science, it's usually anywhere between, I think, 24 to 28 weeks, typically, somewhere in there. And then, philosophically, it's a whole different answer. It's essentially like, when can
Yeah.
you reason is when life begins. So I mean, you're never going to have, the triangle of thought agree on one thing, especially on this. And Roberts kind of gets at that by saying, yeah, we don't need a timing rule. We can probably get rid of that, but they still have the right. Like, there's no need to take away this right. And as you mentioned, from 73 with Roe to 92, it's almost 30 years
Hmm.
of basing a lot of things. There's a lot of abortion cases that came between that time frame that used Roe as a standard. Then after Casey used Casey as a standard, and
Hmm.
then many other rights were justified using the rulings in Casey and the rulings in Roe. So I think Roberts is kind of a little more restrained. And as he says, we need to resolve something a little bit more narrow and not be so broad and
Yes.
sweeping with this decision. Um, he thinks it's fairly grounded in stare decisis. So
Hmm.
he's very much, hey, this has been a thing for a long time. There's no need to overturn it. We can maybe make some adjustments to it.
Hmm.
Obviously, that did not happen, and they, overturned it. But it's comforting to know for Roberts, who is actually more conservative,
Hmm.
that he still recognizes that there is not a reason to really overturn this. Like, you could keep this right and maybe kind of, I guess, I don't say chisel away, but that's kind of what he hints at. Like, maybe chisel it down a little bit,
Hmm.
but still afford that right to the people. I think probably what the better solution, in my opinion, would have been, a woman has the right to choose, and the medical professional, you know, decides if it's a good idea or not. I mean,
Hmm.
I know the right kind of likes to say, hey, people will run around and at birth getting abortions. I didn't do the research on it, but I have a feeling it's probably not that many, if any, are doing
Hmm.
that. And if that is the case, it's usually because something has gone wrong, like very
Yes.
wrong. And, it's more of the safety and well-being of the mother or child, depending what the circumstances are, that something's going to happen.
Hmm.
But usually, most cases are still within the viability framework that was established in Casey. So I don't really think there was really a need to get rid of it. I mean,
Hmm.
this is kind of one of those ones where you're not really winning, and you're also not really losing, depending what side you're on. So
Yes.
it's
Yeah, I agree.
it's tricky, because some people would say, it's great. Like, the conservatives were like, yeah, it's great, we got this overturned. But then you had the incident in Kansas where they tried to amend the Constitution to restrict abortion, and the people were like, nah, it ain't gonna happen. So,
That's right. Yeah.
I mean, it's a rebuttal of what and I would like to say, it's not all conservatives. I think it's a very small wing of the conservative party that unfortunately gets all the media attention, just
Hmm.
like a very small wing of the Democratic Party gets a
Yes.
lot of media attention, and all the other areas that exist are kind of left out and forgotten about.
Hmm.
And the unfortunate part is that that's where most people fall. Like, you could be conservative on gun rights, but be, liberal on healthcare, or, in a whole
Yeah.
bunch of different areas. But those two extremes kind of get all the attention,
Yeah.
and they drive the policy, which is the unfortunate part, is that they're
Hmm.
driving public policy when majority of Americans, I think, like a Pew Research poll was showing, that almost 85% of Americans think that in some fashion abortion should be allowed and should
Hmm.
be a right, which that's a lot. Like, there's almost no issue that gets that much support from
Yeah.
the public. So,
And that was one of the odd things in the majority opinion, because they were trying to act like, there's so much showing us that it's a varied lot when it comes to whether people believe women should have this right or not, whether, we should just get rid of abortion entirely or things like that. And I'm like, are they looking at data? Are they looking at polls? Are they looking at, what the people are saying? But there's also that whole thing of like, that's really not what the Supreme Court is meant to do. They are
No.
looking at case law and looking at it through what they have available to them. And that's where it's I was so back and forth with the majority decision because, like you said at the very beginning, it's like you can see where the holes are in Roe and Casey and why this ultimately got overturned. It's like you can understand little tiny aspects of the majority decision, but trying to act like this isn't something that the broader public agrees on of just the pro-choice aspect. It just seemed like that's not something that they're looking at, even though they were using that kind of when they wanted to in their
Yeah.
opinion. And that was what the dissenting opinion really talked about from Breyer, Sotomayor, and Kagan. They were really looking at the hypocrisy of the majority opinion and also just kind of their inability of looking at the what they called it, the geographically expansive effects of its holding. And they kind of called a few things. They talk about like interstate restrictions will soon be in the offing. And I found that really interesting because I'm like, yeah, they basically called what happened because like there's already been some states that are looking at restricting the ability of women to go to other states to obtain these services. But also just that the majority doesn't really seem to know kind of what they want to use and hold to that because they were using so many different, like I said at the beginning, 13th century, 17th century, and some 19th century things when it comes to health. They kind of really were not looking at the fact that women did not have rights at the time that the Constitution and the Bill of Rights were made, and that if you were to look at what's deeply rooted in our history today, it's that people do believe in a woman's right to choose, that this should be linked to healthcare. And I mean, a host of other things, like that we should have more of a universal healthcare system that brings these kinds of things into the fold. Was there any particular thing in the dissenting opinion that you found intriguing?
Yeah, I'd say all of it.
Yeah.
Because I think they just did a really good job of, you know, they touch on essentially all the things that the majority just kind of let fall by the wayside.
Mm-hmm.
They talk about the geographic implications, which we kind of talked about. Now you have to pay to go out of state to do
Mm-hmm.
it. Well, who does that really hurt? That hurts the economically disadvantaged. You know,
Mm-hmm.
um, you're putting more toll on people to go do this, which would be fine if this was like, a law concerning, murder, robbery, things like that. That
Mm-hmm.
makes sense to have a punitive aspect to it, but not something that in reality, it, you know, this should not be that level of criminality. But that's kind of
Yes.
what they're trying to make it. They also talk about, you know, the rights have a history back to the mid 19th century, what we also talked about. You
Mm-hmm.
know, before the overtaking of, OBGYN care by the doctor profession, it was handled by nurse and midwives, which were predominantly women-led fields, which had a very different approach to abortion and care and all of that. And then again, they also talk about how they relied on abortion and how, it helps into planning lives, how it can kind of work on, even if you want to say you shouldn't use abortion to plan your life, well, you could still argue for all the exceptions, for rape, incest,
Mm-hmm.
all these other things that some states aren't even accounting for and that the majority decision didn't account for. It'd be different if they worked in that there are, exceptions to apply into this rule that, but they didn't. They just kind of went with this blanket. We're just nixing all of this. Um, and it's kind of telling when you have a majority decision that references really far back case law
Yeah.
and then contradicts itself when it talks about the history and tradition of American law
Hmm.
for overturning things, but then overturns something that, yes, technically was never an inherent right through the Constitution, but was a right nonetheless through case law and the history and tradition of the legal system. I'd also say that, politicians have had since 1973 to codify Roe and Casey, and then Casey
Hmm.
92, which is still 30 years or so. I mean, there's been so much time to actually get this to either a constitutional amendment or to put this into federal law, which
Hmm.
usually states will states follow. So I mean, there's so many opportunities that were missed before this case even came up that I think things should also be addressed. That
Hmm.
you know the politicians who are supposed to represent the people kind of dropped the ball on, that I think that even the dissenting opinion kind of touches on in a way. Um,
Hmm.
because I mean they go on and talk about ratifying the Constitution. That when the 14th Amendment happened, women didn't have the right to vote. Women weren't involved in the process. They talk about how it says "we the people." There's no mention that women aren't included in people in the Constitution. People
Hmm.
was all inclusive of all individuals that were citizens of the United States. I mean, it also says citizens throughout the Constitution. That it doesn't even make mention of you know any type of gender. So
Yeah.
it's kind of sad that unfortunately only three people took that dissenting opinion. Even though I'd argue I think Robertson in a way kind of wanted to dissent, he just didn't.
Yeah. Yeah. He was going with the group, the peer pressure.
Yeah.
There were some really startling statistics and facts that the dissenting opinion put out, so I definitely want to cover those before we go. So the first one is that an American woman is 14 times more likely to die by carrying a pregnancy to term than by having an abortion. Experts estimate that a ban on abortion increases maternal mortality by 21%, with white women facing a 13% increase in maternal mortality, while Black women face a 33% increase. Many women still do not have adequate healthcare coverage before and after pregnancy, and even when insurance coverage is available, healthcare services may be far away. One of the things discussed in the majority opinion that the dissent talks about, which is the majority tried to say that like women don't really experience discrimination because they're pregnant. Like these are things that we have, laws or understandings, but the dissenting opinion says that women continue to face pregnancy discrimination that interferes with their ability to earn a living, and that paid family leave remains inaccessible to many who need it most. There's also only about 20% of private sector workers who have access to paid family leave, including a mere 8% of workers in the bottom quartile of wage earners. There was also another aspect of the majority decision that the dissent talks about, which is safe haven laws and the demand for abortion. This was something that was kind of briefly discussed as the leak of the Roe overturning
Mhm.
happened, and that was talking about the I can't remember the exact term. I'll put it up on the screen. But it was talking about the availability of babies for adoption, and that
Yeah.
it was in, I think it was like 2003, that we didn't have enough of a supply of babies for adoption. But it just seems that putting women at a risk of having to not have the financial ability, the maturity level, the just do they even want to partake in the task of having a pregnancy and bringing new life into this world, doesn't mean that we need to, evaluate the demand for adoption, which
That's a
was just kind
weird,
of, it was such a weird thing.
it's an odd supply demand market to be talking about in a legal opinion, but all
Well, and
right.
especially when we have an entire foster care system filled with children, of course they're not babies. So it's like, do people just want little babies and that's all they want to adopt? Because there are tons of children that are in the system that do need good homes.
Yeah.
Foster care is not what we really think it is. It's quite a nefarious institution, unfortunately. And there are so many children that could be in good homes if people weren't wanting just little tiny babies to adopt.
Yeah.
Which, yeah. Another key thing that they bring up in the dissenting opinion is looking specifically at Mississippi, because in the Dobbs case, this was looking at the Mississippi law of wanting to ban abortions after the 15-week mark. And they made a point to say that 62% of pregnancies in Mississippi are unplanned, yet Mississippi does not require insurance to cover contraceptives and prohibits educators from demonstrating proper contraceptive use, and that the state neither bans pregnancy discrimination nor requires provision of paid parental leave. They also have really strict eligibility requirements for Medicaid and nutrition assistance, which leaves many women and families without basic medical care or enough food. And this is unfortunately a really common thing, as the dissenting opinion talks about, that a lot of these states with very draconian laws on the books about abortion are also not providing any type of assistance and care to these women that are having to go through these pregnancies in these particular states. Lastly, just a couple other quick points that I thought were important to make. They said that 86% of pregnancy-related deaths in the state of Mississippi are due to postpartum complications, and that Mississippi rejected federal funding to provide a year's worth of Medicaid coverage to women after giving birth, and that Mississippi is the highest infant mortality rate has the highest infant mortality rate in the country, and some of the highest rates for preterm birth, low birth weight, cesarean section, and maternal death, and that it is approximately 75 times more dangerous for a woman in the state to carry a pregnancy to term than to have an abortion. And they also have no exception for rape or incest, or even if it's an underage woman. So, quite an astounding dissenting opinion. They have a lot of facts. Everything that we've been talking about today is going to be linked in the description box below. We know this was a long one, but thank you everyone for sticking with us and watching this. Michael, do you want to close out with kind of just your go over your thoughts of this case moving forward, and then where can people find your work?
So I think probably the biggest things to take away from this case is just that the implications and effects are going to be unknown probably for a really long time, because we don't know how it's going to affect things, what it's going to be looking at. It's going to be difficult to know exactly how far-reaching it goes and what the court might do in the future. But I think it's positive to think that there are some dissenting opinions, and there have been some wins, like in Kansas, and stuff. Yeah, so I think that the case has really far-reaching consequences. We're not going to know what those may be fully until more cases start coming up, which is unfortunate that more are going to have to come through the court system and have that long legal battle. But there's some positive notes. Kansas, they rejected the idea of amending the Constitution to ban abortions. And the dissenting opinion was pretty strong in its rejection. And even Robert's concurring opinion was also kind of a dissenting opinion in a way, because he was like, yeah, maybe we can change some stuff, but I really think we shouldn't get rid of this right. So when you look at it, if you view it that way, it was really a 5-4 split, almost down ideological lines. But only time will tell, unfortunately. Hopefully, the challenges that come up through the courts, hopefully Thomas doesn't get his way, because that can be really damaging to a lot of just rights that, we've just kind of accepted as being a right. It'd be unfortunate if people are going to lose those rights because they decided we're going to toss out stuff that we've been doing in the legal system for a very long time. And then if people want to check anything out, my Twitter is @thejustadvocate. I think you're going to link it below, maybe. And also my Substack is essentially the same thing, thejustadvocate.substack.com. And today I did release a new article. Has to do with a lot to do with the Dobbs opinion. It also kind of does a deep dive into the history or lack thereof of women's rights in the U.S. and kind of a lot of the legal implications that have been going against women throughout the history of the U.S.
And that is a great piece. I recommend that everyone check that out. Michael, I just want to again say thank you so much for joining with me today, discussing this very, very hot topic.
No, well, thank you for having me.
Yeah, very happy to have you. So stay safe, take care, and remember to be kind to each other.